Hello, good evening, and welcome to another edition of Murray's Law, which is our live Q&A session where we answer your questions that were submitted to us in our free community, the Genius Insider. We have a couple of great questions today that we want to get into, so let's just jump into it. And if you have any questions and we have time left at the end, we will take those questions, just drop them in the chat. Let's see. For those of you who are watching on YouTube for the first time and you don't know me, my name is Attorney LaConya Murray. I am the owner of Mark IP Solutions, where we help clients throughout the United States own their genius and protect their brand through trademarks, copyrights, contracts, and business development solutions through our legal subscription program, the Genius Insider. If you want more information on the Genius Insider, make sure you click the link below in the description. All right, let's jump into our first question. So the first question was sent to me from Instagram. I was tagged on a post on Instagram, and essentially there's a graphic designer who has a challenge out to different designers where they are mimicking other people's brand. One person participated in the challenge and received a cease and desist. She created a flyer, and the flyer had Cardi B on the flyer, and they were using the Cane's trademark. And so Cane's is a fast food place that's based on, like, I was in Cane's when my daughter went to school in New Orleans, and they might have it in Texas. I'm not sure about that, but I do know that they're really popular in New Orleans. And so this particular graphic designer created a graphic for the challenge using Cardi B's likeness and Cane's trademark. And not surprisingly, she received a cease and desist. Now, I say not surprisingly because I know, but the graphic designer, they want to know why. Like, they say that this was just for fun. They weren't trying to make any money off of it, and they were just expressing their creativity. So what's the big deal? Let's talk about it. So again, when it comes to trademarks, most people understand that trademarks allow the owner, when you have a federally registered trademark, they understand that it allows the owner to prevent other people from using their same or similar trademark as relates to same or similar services or products. But what they don't always know is that that same owner, not only can they prevent people from using that trademark to sell products or services that are similar to theirs, they can also prevent them from using that trademark if it may cause some or may allow consumers to assume some type of what can I say, association or support. So you have the ability to do that as a federal trademark owner. Not only prevent them from using your trademark as it relates to your goods or services, but also say, hey, you know what? I don't want to be associated with that. You have the right to say, because this is what you got to realize. When we're talking about brand identifiers and brand protection, it doesn't start at the logo. It doesn't start at the name. Your brand is really a combination of your mission and your values, right? And so if someone wants to use your trademark in something that's not aligned with your actual brand, the inside, like the mission and the values, then you have to be able to say no, because that's a huge part of your brand. And that's what happened there. So there is a such thing as fair use. Someone was asking about fair use. I know typically when we think about fair use, we think about it from a copyright standpoint. However, trademarks also have fair use. So that's why when you see on websites, you have different websites that may compare two different, may compare their brand to another brand using that name or using that logo. They're allowed to do that under fair use. How else will you be able to say, for instance, you know what, go to Walgreens and you look at, anytime you go to one of those pharmacy stores, you will see the brand name product, and then right next to it, you'll see that Walgreens or that Rite Aid or that CVS brand, and they will say compared to whatever. So CeraVe, I'm just saying CeraVe because we use that lotion in the house. So they would say the Walgreens brand compared to CeraVe. Now they're able to say that and use that CeraVe trademark because they're making a comparison. And that's it. They're not saying that they're associated, or they're not trying to sell a product with their name on it. They're simply making a comparison. And you're allowed to do that when you're using a trademark, someone else's trademark. It's one of the limited ways that you can do it. Another limited way would be for someone to say that, I have a client that repairs cell phones. And on that website, there's a list of cell phone brands that they repair, and those brand names. So they might have Apple, Android, the difference, and Samsung. They're allowed to do that under the fair use exception because they're saying that they're able to work on these brands. They're not saying that they own the brand or anything of that nature. As a matter of fact, at the bottom of the website, there's a disclaimer that these trademarks are the registered property of their respective owners, but they're allowed to use that trademark name and say, hey, we can work on this. And so that's a limited exception. Parodies, parodies are just like with copyrights. A parody, if you're kind of making light or fun of something, you can use it in a fun, joking way. And another exception would be when you're, just like copyrights, when you're doing a news article or doing some type of editorial, you would be allowed to use it. But those are the limited exceptions. Creative expression, it's not a fair use exception. So that's why that happened. Let me check my next question here. So that was a good question. I'm glad that they sent that to me. So if you ever see anything like that, make sure you send it to me, because I am very interested, and I do want to make sure that I can tie this in to what you're doing. And so the next question, let's see, the next question would be LLC. LLC, well, it's really about a trademark. The question is, when I get my trademark, I want to trademark my LLC. Do I have to include the LLC on my application? And that's a really great question, because essentially what you have to register, what you have to know about your trademark application, and when you register it, is that what you're registering is how you use it to the public. Meaning that when you're doing your marketing and advertising, you don't always add that LLC on there. Your trademark shouldn't be LLC. Your LLC, that LLC is for the state. It represents your business name. It can be different from your trade name. So when you're filing your application, you have to keep in mind, like, when I'm marketing, when I'm telling people about my business, am I always using LLC or Inc. or whatever the case may be? If you're incorporated, Gap Inc. that's their business name. But when we go to the store, it just has Gap up there. And so when they file their trademark, they're only trademarking Gap. So that's a really great question. And the next question is, which one do I get first? Like, how do I do this thing? Which one do I get first? And the answer is, it depends on where you are in your business. So of course, that when you're starting a business, there are going to be different phases. You're going to go through the planning phase, the preparing phase, where you're getting into contracts and things of that nature, then you're going to launch. So depending on where you are in your business, there's going to be a place in your business where you are doing the planning and preparing, but you're not necessarily doing business with other people, where you will be in jeopardy of losing your personal assets. So that's what the LLC does. That LLC protects your personal assets from your business liabilities. So if you're not in that position yet, one thing you want to make sure you have done is your trademark, because what you don't want to happen is for you to go through this whole thing, prepare to launch, and then receive a cease and desist letter because you're infringing on someone's brand. Because you've done all this planning, invested all this money in marketing and branding, but you're infringing on someone's trademark. So no matter which way you go, the first thing you want to do is make sure that your trade name is available. Keep in mind, we just talked about your business name. Your business name in most states doesn't have to be the same as your trade name. So for us, our business name is Murray Law Group LLC, but our trade name is off the mark, That's what we do when we do our advertising. We do off the mark or off the mark IP solutions. Matter of fact, can we just take a pause for the calls and talk about this this email that I got the other day? So we had a press release go out for our Genius Insider program, which is really dope. If you haven't heard about it, make sure you click the link below. But essentially, it's a legal subscription program to help entrepreneurs have access to an attorney and their legal needs at a really great price. But someone emailed me after they got the press release. They said, "Oh, the service looks really interesting, but I have a hard time. But I noticed that you don't have a trademark for your Murray Law Group LLC or off the mark IP solutions. How can I trust an attorney who doesn't? How can I trust you to help me with trademarks if you don't have a trademark yourself?" And that's where this whole business name versus trade name comes in at, because my business name is Murray Law Group LLC. Why would I trademark that? Like, how many Murray laws are there? I know there are more than one, because when I was doing criminal and family law years ago, I would get calls from this other attorney who had the same last name. So I wouldn't trademark that because it's not unique. When you get a trademark, you want to make sure that it's unique. I also didn't trademark off the mark IP solutions because IP solutions is descriptive and I can have no claim over that, which is why when we do our branding and our marketing, we just use off the mark, which is what we do have a trademark for. Y'all, it's about strategy. That's why you can't let just any old body tell you what you should and should not be doing and how easy it is, because yes, you might get a trademark. Maybe you file it yourself and it goes through, but did you file it for the right thing, the right class and what you're using? Anywho, back to what I was saying. But so as it relates to you launching, to preparing to launch, you want to make sure that you do a trademark clearance search to make sure that name is available before you go down this rabbit hole of branding and marketing. Because the worst thing in the world, I've had this happen multiple times, is to invest thousands of dollars into branding and packaging and receive a cease and desist letter. And you having to start over from scratch. You don't want to do that. I've even had some cases where they might have been using the name first, but because someone else filed a trademark before them, it would cost less for them just to go ahead and rebrand than to fight it out legally. So that's the first thing you want to do. So it's never a question of trademark or LLC. They're not the same thing. A trademark is for your consumer so they can readily identify the source of a good or a service. Your LLC is for the state so they can readily identify who's doing business in their state and get those coins so they can go ahead and collect their fees, their taxes. So it's not an either or thing, but that's a really great question. Let's see what else we have over here. Let's see. The next question. Hold on. Someone wants to know that if they are looking, because we talk about trademark clearance searches a lot, if they're searching the database and they come across a trademark that's dead, does that mean that it's not registered anymore? And that is true. That means that it's not registered anymore. But what you have to know that just because it's not registered doesn't mean that someone's not using it as a trademark. Remember, in the United States, we have common law trademarks. First to use is who has priority. So, and there's another thing about a dead trademark too, is it can be dead, but if they're still using it, if it hasn't been 3 years, then you want to keep doing your research. Like, you don't want to see that dead indication and be like, oh yes, it's available, because it might not be. So anytime I come across a trademark that's dead, I go down the rabbit hole of seeing why it's dead and checking and see if they're actually still doing business. Let's see. Someone wants to know, can you trademark your name before you have a website or things to sell? That is a great question. So that goes back to what we were talking about before about launching, right? Going ahead and taking care of your trademark before you actually launch. So before you actually launch, your product is not available for sale. You don't have your website, but you're making sure that your name's going to be available when you do launch. And so, yes, the answer to that question is yes, if you have a bona fide intent to actually provide that service, meaning that trademarks aren't domain names. Trademarks aren't domain names. So if you are looking to just reserve a name to make sure that nobody has it because it's a cute name and you might do something with it, but your main thing is just to hold on to it, that's not a bona fide intent. So, but if you do have an actual intent to start this business, so, but right now you're just in the planning phase, and then you're going to be in the market development and research phase, and then the product development phase, that's another story. So if that's the case, then you can file what's called an intent to use application in order to make sure that your name is available when you get ready to launch. So goes with the trademark clearance search. You file your application with the intent to use status so that you're protected when the launch comes. When you file that intent to use, you're telling them, hey, I'm not using this right now. I am not using this in commerce now, but I have a bona fide intent to use this trademark in commerce. And then they will go ahead and process your application. But instead of issuing you a certificate of registration, they're going to issue a notice of allowance, which is going to give you 6 months to begin using that trademark in commerce. Now you can start using that mark before then, but if you sometimes launches in development take a while, and if that's the case, if they take a while, then you can file, you'll have basically from the time you file your application, right? It's going to sit in the database. Now it used to be 3 months, but now it's 6 months. So that 6 months that you have to plan, then it's going to go through the process of the examining attorney, which can take a few weeks. And if you have an offers action, that can take up to another 6 months or even 12 months if there's a back and forth, right? And then it's going to go to publication for 30 days if you overcome whatever objections the offers action had, the examining attorney had. So essentially you can have up to 2 years before your notice of allowance is even due. That's a long time. So that gives you a long time to get your stuff together to sell. But the answer to your question is yes, you can file an intent to use application without having your website or your goods available to sell. And that's the last question that we have. I'm going to check over one more time, just over to the comments and see if we have anything. Cool beans. I don't have any others. Those are all the questions we have. Someone's watching on YouTube. If you want to say, hey, definitely let me know. If you have any questions, drop them in the chat and I will get your questions answered. But the questions that we had tonight, I think they were really good. If you want to see the replay, definitely go to the Genius Lounge. They will be available. The video will be available in the Genius Lounge. If you want to learn more about our Genius Insider program, our legal subscription program, which is, I keep telling you, it is really dope. Everybody loves it. Our insiders love it. And essentially, if you're looking to be able to have free consultations, free document review, access to contract templates for less than $700 every 3 months, check it out. The link will be in the comments. Like I said, that's all I have. Until next time, beautiful people, keep building your business, growing your brand, and owning your genius. I'll see you next time.